Shut it. Shut it. Where's Tom Wilson? He was here a while ago. I don't know. Y'all pray with me. Gracious Heavenly Father, again we come asking you to forgive us of our sins, to say thank you for the blessings that you continually give us, whether we deserve them or not. Give us wisdom, give us character, and Lord, give us some compassion. Lead us and guide us, stay with us, keep us in your arms. I ask these things in my Savior's name. Amen. Good morning. Be quick. The line's getting long. Mr. Dollar.
Thank you, Mr. Chairman. Today I have for the committee HB 245. It's at the very top of the list. This bill might sound familiar to the committee. It was passed out of the committee and full House last year. As many did, it ran out of time in the Senate. What this does is it changed the amount that condo associations can charge for special assessments. Currently, that fee is capped at $200 per year. We are one of 2 states in the country that have such a cap at all, and that $200 amount was set 25 years ago. The idea behind this bill is that currently what the system is such that these associations raise the monthly fee every year in order to get the funds that they need to do the projects. This will hopefully stem that. This does raise the amount to 1/6 of the annual dues collected, so 2 months worth of dues is what this raises it to.
Mr. Ramsey.
You touched on this briefly, but this just basically kind of gets us in line with other states, but still kind of keeps us on the lower end of the range of what we allow condo HOAs to do in terms of these assessments for property owners.
Exactly. I still wanted a cap, and I think many on that I've talked to about this bill have the same feeling, and the reason we're setting it to the dues, that way we don't have to come back 5 years, 10 years, 20 years from now and raise it, from 500 to 1,000 or what have you. This should kind of operate on its own from here on out.
Thank you.
No other questions. Thank you.
Thank you.
Mr. Parsons.
Thank you, Chairman, ladies and gentlemen. House Bill 200, it's on page 2 of the structured rule. This is a bill, there's currently an income tax credit for the cost of installing an electric vehicle charging unit in what's termed a business enterprise. What this bill does is there is no yearly cap, and there's no sunset on it currently on that income tax credit. This bill actually sets a sunset on it, and it also puts a yearly cap on that income tax credit, and further clarifies what kind of business can receive that income tax credit. And that's pretty much it. It does include, we did expand it to include what's called I think it's a CNG appliance charging unit, and that's a kind of unit that people would actually put in their house. There's not many of those put in. It requires a lot more infrastructure than an electric charging unit for an electric vehicle. And that's pretty much it on that bill, Mr. Chairman.
Any questions on that bill? He's got another one. No question. Whoa.
If I...
Mr. Roberts.
Thank you, Mr. Chairman. Back away a little bit. Mr. Chairman, over here.
Oh, okay, yeah.
On this, we're only dealing with electrical, or are we dealing with gas as well?
Well, it's really for electric vehicle charging units, but we also included what is, and I can't remember, I don't have the bill in front of me, it's called an appliance. It's for CNG type vehicles. It's almost is an appliance that you put in at your house. I mean, there's not many people put those in at their house, and it's just kind of a special situation. It's kind of an exception, but it does give it would also extend that to that appliance for charging or for fueling your CNG vehicle at your house. And it wouldn't have to be at a house. It could be at a bit, but it's not like going to a CNG filling station. You know, the big deal and the big tanks and all that. It's just it's an appliance that you would put in at your house. Mm-hmm.
One further question, and I apologize, I hadn't had a chance to read this. I'm going to go back and check this bill. Right now, currently, if you are using CNG in your vehicle, you have to pay it's a tax rate equivalent to a motor fuel tax.
That is correct, yes, sir.
Does this any way affect that whatsoever by allowing them to come in?
No, it does not. It's just purely for the income tax credit, extending that to the cost of installing that piece of equipment.
Thank you, Chairman. Thank you, Mr. Chairman.
Next one.
Mr. Chairman.
Wait a sec. Mr. Hamilton.
Thank you, Mr. Chairman. I just want to clarify. So we're doing away, or we've recommended, or currently there's legislation doing away with the tax credit for electric vehicles, but in this particular case, we're increasing the tax credit potential for the chargers that are used?
No, sir, it really isn't. There is currently, for this particular tax credit, there is no annual cap at all. Currently, there is no cap, there is no sunset, it's just in existence. This actually puts a yearly cap of $750,000, and also limits the amount of money to, I think it's $250,000 or $25,000 rather, for any particular company. That may not be the right figure. I don't have but the $750,000 cap per year would go into existence with this bill. There is no cap now.
But if I may, on line 18, we're increasing the personal exemption from 10% to 20%. So we're increasing the ability to the person that obtains it.
It is, I think, for the first 2 years, something like that.
That's fine.
But there is no, here again, there is no annual cap at all. I mean, literally, if this thing were used as it is now, there would be nothing to limit the amount of money that could be given out as a tax credit currently. Really what it's doing is it is further defining, it's actually defining who can get it and putting a limit on it, how much can be given out as a tax credit, and putting a sunset on it. So it's really improving what we have now.
Next bill.
Mr. Chairman.
201.
Could I just mention, 201, that is correct. That's the one I brought yesterday. Really all that bill is doing, I presented it yesterday, but all that bill is doing is giving the PSC a little more leeway in the way that they can administer a program that provides equipment for people who are deaf or hard of hearing. And that's really what that bill does.
No questions. Thank you.
Thank you, Mr. Chairman.
Ms. Tankersley.
Thank you, Mr. Chairman and committee members. This morning I bring to you House Bill 312. It's about tobacco products, manufacturers, and importers. It's on page 2, second from the bottom of our form. This is a DOR bill to repeal the tax bonding requirements for the tobacco manufacturers and importers. This bill may seem familiar to a lot of you because it too made it through the House this past session and through the Senate committees, but was not heard in the last days. This bill does just simply remove the annual performance bond of not less than $1,000 requirement for the manufacturers and importers because they have no tax liability. Therefore, there's no need to secure a $10 renewal fee with that performance bond. Tobacco distributors do have an ongoing tobacco tax liability, and therefore their bond shall remain in place. I ask for your favorable consideration of House Bill 312.
Any questions? Thank you. Mr. Harrell.
Thank you. On the second page, under structured rule, third from the bottom, House Bill 276. This is a modernization and update to Title III Alcohol Code. It's a 50-page bill with 82 sections. The reason of the length is we've taken definitions throughout the title and moved them all up front to make it clear and easy to understand. We've done the same thing with license requirements. We pulled license requirements throughout the title, brought them all up front, put them in one place. That's what primarily caused the length of the bill. Be glad to answer any questions.
No questions. Thank you.
Thank you.
Mr. Tanner. We've decided, Mr. Harrell, after all these alcohol, but you have your own still. Is that?
Mr. Chairman, I bring under modified structure, second down on the first page, under modified structure, House Bill 114. Mr. Chairman, this is the bill that I came with you last week. There was some questions surrounding that from Chairman Earhart and Chairman Willard. We've worked with DDS and AOC on this issue, and along with some of our traffic court judges. Their feelings are that they understand the underlying concern by Chairman Earhart and Chairman Willard, and that they feel like there is things that we need to do to correct that, but this legislation will not make that issue any worse than it currently is, and they feel like, and I agree, that it's going to take longer than what we have this session to fix the underlying problem. Chairman Earhart's in agreement. I think Chairman Willard may disagree with that, but on behalf of DDS, I'm here asking for this legislation.
When I looked down there and saw the exasperated look on Mr. Willard's face, I knew that he wasn't in agreement. Okay, what's the other one?
That's it, Mr. Chairman.
You just have one on here?
Yes, sir.
That's another miracle. No questions. Thank you. Mr. Teasley.
Thank you, Mr. Chairman, members of the committee. The fourth one down in modified open rule, just wanted to come back and ask you again for House Bill 126, which would remove it's technically illegal to have a GPS device mounted to your windshield. So this would create a special exemption to make sure that you can post GPS device on your windshield. Talk to folks in the Department of Public Safety, and they don't have a concern with this.
Any questions, Mr. Teasley? No questions. Thank you. Mr. Hightower.
Thank you, Mr. Chairman. Members of the committee, under modified open, sixth up from the bottom, HB 304. Again, this deals with someone has been sentenced to imprisonment time followed by probation. This simply says the sentence shall specifically provide that the period of probation shall not begin until the defendant serves all the confinement time, even when you have consecutive sentences running together. This is just a clarification bill. We presented to the governor's office. It was just a misinterpretation of the law through some of the criminal justice reform projects. Very straightforward.
Any questions of Mr. Hightower?
And Judge, I mean, not Judge, but Mr. Chairman, get so used to presenting in court. There was actually a judge that did this. He said that there was a sentence that was void because it didn't follow this, so this is something that's very important for us to clarify. It could be the judge and jury, though. I give you credit either way.
You know how lawyers are. They get wordy. I was letting you out of here pretty quick, so bye.
Thank you, Mr. Chairman.
Mr. Kelly.
Thank you, Mr. Chairman, members of the committee. Right on the middle of the first page under modified open, House Bill 267 is just seeking to make clear the proper witnesses that are needed to record a security deed. This is basically just clarifying what we've been doing in law for years, which is having a notary public as well as one witness. There's been a recent Georgia Supreme Court case that's kind of thrown that off a little bit and caused some concern for our national title underwriters, and we're just trying to set the ship back on smooth waters.
No questions. Thank you.
Thank you.
Smooth water. Smooth water. Mr. Lumsden.
Good morning, Mr. Chairman, members of the committee. I bring to you House Bill 338. It is under page 1, modified open rule. Fifth from the bottom, this is the bill that I presented to you last week. We have worked with Chairman Rice in regard to an issue that was raised about the sunset date, and we will be offering an amendment on the floor for that. So I thank you for your consideration, and I'll be glad to answer any questions.
Any questions, Mr. Lumsden? Ms. Jones.
What is the nature of the amendment?
It changes the sunset date from 8 years to 5, from 9 years to 5 years.
Thank you.
Thank you.
Mr. Strickland.
Thank you, Mr. Chair, members of the committee. I have two under modified open rule. The fourth and third from the bottom, House Bill 366 and 368. 366, Department of Labor bill that creates more efficiency for the department. It eliminates the ID requirement for 16 and 17-year-olds that are working. It also streamlines the process for homeschoolers. And the last part of the bill actually addresses the issue our film industry is having with privacy under the records that are kept by the Department of Labor.
Any questions, Mr. Strickland? All right.
Then House Bill 368. This is simply a cleanup housekeeping bill, really is that for Department of Labor. It strikes the code section that addresses the regulation of safety glazing on glass. It's completely regulated by the feds now. It's not something our department deals with at all anymore.
Any questions on 368? Thank you. Mr. Rutledge.
Thank you, Mr. Chairman, members of the committee. Asking HB 120 on the backside, second one down on structural rule. Again, just asking, this basically will allow local governments, if they so choose, to add to their SPLOST list government-owned, state-owned facilities.
Any questions? Thank you. Wait a second. Wait. Whoa. Mr. Leader.
Could you give me an example of how that might manifest itself?
Technical college, I guess soon to be career college. Yes.
That could be a SPLOST project.
Mm-hmm. If we
at the end of the SPLOST, who would own it? Would it still be?
It would just be a partnership to expand or improve a current facility that's owned by the state. And local government, could have the option of partnering with them to do an expansion.
But who would?
The state would.
Who would own the improvements in that scenario? Would the state own it and local governments pay for it?
Correct.
Okay, thank you.
Mr. Rogers.
Thank you, Mr. Chairman. Representative Rutledge. I assume this includes new properties going forward.
Oh, there you are. Okay.
New properties going forward, nothing in the rear, correct?
New expansions going forward, I would.
New expansion.
Right.
Further question, Mr. Chairman. Department Public Health, like in the area I represent, the county owns the property. They pay a long-term lease, an expensive lease. So are you saying under this bill, under a SPLOST vote, they can expand that property? Is that what you're saying?
This is for facilities that are owned by the state.
Okay, owned by the state, but not state occupied.
I mean, I'm not sure I understand what.
Well, example, the county owns a piece of property, they lease it to the state. So the state could come back, or they could put it on a referendum. If the state wanted to acquire it on a SPLOST vote, then the state could acquire the property. I'm trying to follow up to what Leader O'Neill was asking you. Would not?
I'm not.
Thank you.
Mr. Powell. Jay.
Isn't it true that local governments are doing this already? but they're doing it with convoluted intergovernmental agreements, and this just streamlines it and lets them do what they're already doing, but with a lot less lawyer fees and a lot less complicated legal documents.
Correct.
A lawyer asking for a lot less lawyer fees?
In somebody else's district.
Oh, okay. No more questions.
Thank you.
Mr. Donahue.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen of the rules. I come before you again with HB 299, convenience fee bill. In the state of Georgia, we already have the opportunity for a convenience fee to charge on credit cards. However, GILA, the Georgia Institution of Regulatory Loans, basically does not have the same privilege. And all this bill would do would present them with the opportunity to recharge any cost occurred to them from using debit cards, credit cards, and using electronic payment.
Any questions? No questions.
Thank you.
Ms. Ballinger.
Thank you, Mr. Chairman, members of the Rules Committee. I come before you on behalf of HB 253. It's middle of the page on page 1. Basically, this is enabling legislation to allow for appraisers to appeal to our local real estate, our state real estate commissioner, as opposed to having to appeal to the federal level.
Any questions of Ms. Ballinger? No questions. Thank you. Ms. Quick.
Thank you, Mr. Chairman. On the second page, ladies and gentlemen of the committee, the second from the bottom under modified structure, HB 367, I'm proud to carry this creation of the fourth judgeship bill on behalf of the Athens House and Senate delegation. This would implement the recommendation of the Judicial Council of Georgia with regard to the Superior Court workload assessment. And Mr. Chairman, this is either third lucky charm 3 times or 3 strikes you're out. I would ask for your favorable consideration.
A lot of people strike out.
Yes, sir.
No questions. Mr. Carson.
Thank you, Mr. Chairman. Members of the committee, back page under structured rule, first one, House Bill 20. What this essentially would do it's in regard to low-income housing tax credits. It would allow Georgia entities to allocate the Georgia tax credits within those partnerships regardless of the federal income tax treatment of the partnerships. This is identical to House Bill 683, which was passed with over 160 votes last year, but held up in the Senate.
Any questions, Mr. Carson? No questions. Thank you. Mr. Spencer.
Morning, Mr. Chairman. Asking for House Bill 69. It's on the first page, the first one under modified structured rule. There's a federal regulation, a mandate that has required vehicle black boxes or event data recorders in your vehicle, and they have essentially created a conundrum as to who actually owns the information. Is it the owner or some other entity? So what 69 tries to do or attempts to do is to make sure that the owner of the vehicle is the one who owns the data.
Any questions, Mr. Spencer? No questions. Mr. Belton.
Thank you, Mr. Chairman. I'm asking for your favorable consideration of modified open rule the number second one under there, HB 103, Kelsey's Law. It basically says that you're not allowed to put a minor's personal information on a pornographic website. I hope you'll get your favorable consideration.
Any questions? No questions. Ms. Beskin, and Ms. Beskin, don't use the word stupidity in this room.
Good morning, Mr. Chairman. And
unless you're talking about another lawyer, that'll be all right.
Good morning, Mr. Chairman and members of the committee. I'm here today with a pretty straightforward bill. I can't think of anything clever or even especially interesting to say about House Bill 297, which relates to professional licensing boards. This provides that a state licensing board may but need not contract with the National Association of State Boards to process its examination applications. This bill was brought at the request of the Architects Board, and it would streamline the process of getting people to work, and I ask for the committee's favorable consideration.
Any questions of Ms. Beskin? Thank you.
Thank you, Mr. Chairman.
Mr. Williamson.
Thank you, Mr. Chairman, members of the committee. I'm here today to ask for your consideration of the committee substitute to House Bill 237. And it's the extension of the angel investor tax credit. It simply extends the sunset period 5 years out. All of the aspects of the bill remain the same. I'd be happy to answer any questions.
No questions.
Thank you, and ask for your favorable consideration.
Why don't I have that? Why don't I have 237? Yeah. Okay. Mr. Gravely.
Thank you, Mr. Chairman, members of the committee. I ask for your favorable consideration on HB 169, which is on the back of your page under Modified Structure Rule. Chairman Knight had a really good question yesterday, and I'd like to better answer that question this morning. In the 13 counties that require an emissions test, drivers can have their insurance up to date, their title free and clear, but if they do not pass an emissions test, they are unable to get their tag renewal. What this bill seeks to do is simply allow the tax commissioners in those counties the opportunity to issue a temporary tag for 30 days while the driver goes and fixes their vehicle or gets whatever needed maintenance is needed for the car to take it back and have the emissions cleared. The problem currently is that while these drivers are asked after a first fail of emissions, they usually need to drive 150 miles to 200 miles to recalibrate. Well, they're on the roadway at that time and they're subject to a ticket for not having a renewed tag. The 30-day temporary tag, which is already in production in the state, would allow them to drive the allotted mileage and allow them to get the maintenance done and be able to return back to the tag office to get their renewal.
Any questions, Mr. Gravely? No questions. Thank you.
Thank you, Mr. Chairman.
Mr. Mitchell.
Thank you, Mr. Chairman, members of the committee. I come before you once again for House Bill 115, modified open, page 1. Certainly great legislation. We will most certainly allow some consumers to avoid foreclosure, well vetted by the Judiciary Committee. Thank you, Mr. Chairman.
No questions. Mr. Hamilton.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I have two bills to ask for. On the first page at the bottom of modified open, House Bill 12, which is the workers' compensation change that's been well vetted through the advisory council. And on page 2 at the top of the page, close to the top page, House Bill 194, which deals with early voting times.
Any questions of Mr. Hamilton? Mr. Weldon.
Thank you, Mr. Chairman. I'd like to ask for House Bill 212. This is just clarifies the rule on pain management clinics and how CRNAs can perform their duties. And I'd also like to move that this be moved from modified open rule to modified structured. Also on the back page, top of the page, House Bill 154, magistrate courts. This just brings parity to the probate courts and magistrate courts with respect to holding a lawyer in contempt.
You hadn't been here long enough this week or last week to make jokes. Mr. Roberts.
Thank you, Mr. Chairman. Simple little housekeeping bill. House Bill 170 is back in Rules Committee. The only changes that were made from this bill from last time to this time, we allowed for local governments to go to 1.25 is in July of 2016 versus July 15. We also, I got to think of everything. I just went over them all. I apologize. We took transportation out of level 1 projects. We also have allowed ACCG and GMA to come together, and the school boards and all have, on this bill finally, I think have come together and singing Kumbaya to a point, but which kind of concerns me, Mr. Chairman, but that's where we're at right now. Yeah, locals get to charge diesel. I'll sing it to you later. Yeah.
Any questions of Mr. Roberts? No question. Mr. Hamilton.
Thank you, Mr. Chairman. At the appropriate time, we'd like to make a technical amendment to House Bill 170.
I want you to tell us what that technical amendment is.
Thank you. If you'll turn to page 7 of the bill, and this was brought to our attention by a very esteemed lawyer that indicates that if we leave the wording as is, we might be potentially in jeopardy of some federal funds. And so on line 230, we would ask to strike no and replace with all, and then strike on lines 231 beginning at A, so we would leave be used for, and then strike A in the remaining part of that sentence and replace that with airport aid within Georgia Department of Transportation which receive federal matching funds. Sure. So we would change no to all, strike a purpose that would result in the loss of any federal funding, and replace that with airport aid within Georgia Department of Transportation which receive federal matching funds.
Everybody hear that? What we're going to do is tomorrow Mr. Hamilton will bring an amendment to rules and have it printed for you to show those things. Mr. Green.
Thank you, Mr. Chairman. House Resolution 395 creates the Georgia-Alabama Study Committee. Some time ago, the state of Alabama approached the Speaker of the House, and the Speaker approached the members along the Chattahoochee River to try to coordinate a joint study committee where we would look into conditions, needs that presented itself across from Alabama and Georgia there. and there's an abolishment that it will stand abolished on December the 1st, 2016. We're going to try it and see if it works in working with our Alabama colleagues.
Just to remind y'all that joint study committees have to be in before the 30th. Joint, not just House, but joint. Okay. Mr. Benton. Mr. Burns.
Thank you, Mr. Chairman. Second page on structure, HB 339. This simply looks to extend the tax credit on the interactive entertainment industry that was part of the governor's competitive legislation a couple years ago and last year. Extends it for 3 more years. This portion of industry has been very successful in attracting jobs to Georgia, and it helps us remain competitive in the area. The total fund would be capped at $12.5 million. That's all per year. That's what's available. A company would have to have $500,000 worth of investment in Georgia jobs, Georgia payroll each year to qualify for up to $1.5 million. That's all they can qualify for the year. The good thing that we've done in this bill, the legislation, the language we've included now for the first time helps us we've created a metric so we can measure and have good information when we come back and look at these issues in years to come to make sure they are doing what we intended for them to do. They're creating jobs in Georgia, and we believe this is really the blueprint we'll move forward with to ensure that we're getting the most bang for our buck when we look at these tax credits. That's it, Mr. Chairman.
Any questions? Mr. Roberts.
Thank you, Mr. Chairman. I apologize a while ago on 170. There's one thing I failed to mention in that bill that's a big difference from last time to this time, was the fact that we are doing away with the exemption on aviation motor fuel by qualifying airlines. That amendment was added in committee yesterday, and I want to make sure everybody's aware of that. And I apologize for not stating that earlier.
Any other member? All right. We're going to be setting tomorrow's, Wednesday's calendar. Under modified open, HB 412. Any opposition? Under modified open, HR 395. Any opposition? It's on. Under structured, HB 275. Any opposition? It's on. Under structured, HB 276. Any opposition? It's on. Under structured, HB 312. Any opposition? So, under structured, HB 339. Any opposition? Under modified structure, HB 348. Any opposition? That's it.